Why, thank you, Adam. And happy spring, everyone. Thanks for joining us this lunchtime. Also, thank you for, when you registered, posing some of your questions ahead of time. Because sometimes you do ask questions that do require some research. This is a relatively complex system, which is one reason why we do these seminars. And so with regard to some of the questions that we received ahead of time, if these were from you, we will definitely be spending time discussing the benefits and time off of work in the comp system. We will certainly be showing the steps employers ought to be taking, as well as workers. We will discuss how to get travel reimbursement. And also, if the worker is outside New York State or outside the U.S., we will talk about the medical care aspect as well, because the claim follows you. So you still have a valid claim if you have a valid claim, no matter where you are. However, I would like to just call out paid family leave, because we do webinars devoted just to paid family leave, and you should certainly sign up and take one. You might even hear Adam again on those webinars. And then with regard to FMLA, we do not cover the Federal Family Medical Leave Act because it is a federal law. So it's outside our jurisdiction. We're the state of New York. So let's begin right now at the beginning, before there's ever an incident, before anyone's ever sick or hurt, or in the worst instance, before someone should ever perish. Why don't we all work together to create safer workplaces? Here is an idea that is tried and true. Why don't you form a labor management safety committee in your workplace? It's a very simple idea where the workers and the management get together and they meet predictably and they discuss the places in the workplace or the procedures in the workplace or the equipment in the workplace that could injure someone. This is your opportunity to get together and mitigate accidents from ever happening. If you are seeing a problem in your workplace, this is where you would come and talk about the safety elements and try to correct what's happening so no one's injured or sick or no one perishes. This is a very simple thing. It's free, and we urge all workplaces to engage in this kind of dialogue. Our agency has a Labor Management Safety Committee. So now we're going to turn to workers' comp. What is this thing that we're discussing? Well, it's a worker's right. It is a no-fault insurance system. So let's look at that for just a moment. It's a no-fault insurance system. No fault, we're all in New York probably familiar to no fault from the concept of auto insurance. It's the same idea to the extent that who's responsible for this, who is at fault. These are not things in the workers' comp system. It's also an insurance system, which means somewhere in the mix, there is an insurance payer who's going to pay these claims, and we will illuminate you on that topic in about 5 minutes. The employers must provide this insurance coverage, and the workers do not contribute to the cost of it. Also, workers, you're entitled to this just by virtue of having this legal right. So you cannot sign this away, you cannot negotiate it away, but to answer one of the questions we got ahead of time, the rights and benefits that we're going to discuss today, you can think of as a minimum, because it is absolutely possible for employees and employers to negotiate a richer benefit. That's fine. That usually tends to happen with a collective bargaining agreement, but it could happen in other circumstances as well. Immigration status is not a factor. This is one of the few places in the system where I can make a categorical statement. Immigration status is not a factor in workers' comp, period. There are no questions about where you were born, when you came to the U.S., etc., etc. No visa questions. It's just not a factor. Finally, language assistance services are available. We will translate hearings, or interpret hearings actually, live for workers when they happen at no cost. We also have our we have our publications available in all those languages on the left there that you can see. Those are readily translated, and if you would prefer to speak or write to us in a language beyond those, don't worry about it. Go on ahead. We will reply to you in your language, the language that you prefer. So that's the web page that Adam's brought up for us. All the resources on languages are right there. So the Workers' Comp Board, that's Adam's employer and my employer. We are a New York State government agency. We oversee the comp system. We do not pay the claims unless, and the spoiler alert, pardon me, the spoiler alert is if the employer is not carrying insurance and should, well, we'll talk about that in a few moments. There are about 1,000 of us at 24 offices and hearing points all across the great state of New York. How do we oversee the system? Well, we receive the reports of injuries, the reports of payments, we receive the medical reports, and when it's necessary, we will hold a hearing in front of one of our law judges to move the claim forward. There's also this advocate for injured workers. Well, that's me, and I am the manager of an office of people, and we help workers with the more difficult claims, the more complex claims. Well, sometimes we're referred to as the office of last resort because you can call us or write to us, and we will help you out with your inquiry and with your accessing benefits. We help workers access their benefits. We are also involved at the start of almost all fatality claims because we'll help the families with that. And also, we work with the September 11 community. I do that mostly myself, but we do have some resources available for folks who responded to that disaster. And you can see on screen, we're showing you the big three right across. There's the World Trade Center Health Programs. That's not us, but here's some info. We want you to get there. There's the September 11 Victim Compensation Fund. That's federal. That's not us, but we want you to read this because that might pertain to you. And also, if you are a volunteer, you could come and file a claim with us. The point here is the World Trade Center disaster happened 21 years ago, but the effects are still being felt today, and we will help you as well as we can. And finally, I am an ombudsman. That means I care about the health of the system. So that's why I report directly to the chair of the board, and I try to keep track of the performance of the system and the health of the system and make sure it's operating properly. New topic, who pays your workers' compensation claim? All right, this is foundational. This is very important. There's going to be insurance in some format available to pay this claim. So there are two ways to do it. There's a policy and there's self-insurance. So buying a workers' comp insurance policy is the most prevalent manner. That's about 2/3 of the marketplace chooses to do that. So to buy that policy, an employer can either go to the New York State Insurance Fund, that's not us, it's the New York State Insurance Fund, and they insure about 1/3 of the market. The next third of the market is insured by commercial workers' comp insurance carriers. And then finally, the last third of the market is covered through what's known as self-insurance. That means the employer has the financial resources to pay the claims out of its own funds. Now, the two variations there are private employers and public employers. Public employer is a government entity, town, city, school district, and they can self-insure, and the majority of them choose to self-insure. On the other side, a private company, can self-insure, but those tend to be multi-billion-dollar international corporations who would have the financial wherewithal to do this. And the board permits them to self-insure after they demonstrate to the board that they have the financial resources and they have set aside the proper resources to be self-insured. The point I want to make here is when you're self-insured, you are probably hiring a claim administrator to handle the claims. So you're not going to handle it through like your human resources department, your personnel department. No, there's probably going to be an administrator who's actually handling the claims. Now, on the other side, the policy side, the insurance company is going to be handling the claims. So this is a long way of saying if you're an injured worker and you have a claim, your supervisor, your personnel department, they're probably not going to know anything about the claim. They're certainly not going to be directing the events because the claim is going to be handled by the insurance carrier or the claim administrator. Essentially, the employer is out of the equation once the claim is filed because then it tends to be a matter handled between the worker and the payer. Finally, the last bullet on screen, yes, if an employer should be carrying insurance and is not, and there's an incident, the board will advance the payments, and then we will bill the owner of that entity personally. So if you're a worker and you get injured, don't stop to worry about whether the employer has insurance or not. Just file the claim and just file the normal process we're going to discuss. Let us worry about who the insurance payer is. Here's an adjacent topic. Who needs coverage? Well, it's pretty simple. If you're a business, and by business we mean you're a for-profit endeavor, so if you are a business and you have employees, you need the insurance. Even if you have one part-time employee who happens to be your niece, you still need the insurance. Also, just as an aside, if you're the owner of that business, did you cover yourself on the policy? Because you don't have to. The owner is permitted to exclude themselves. However, do you really want to? Because what are you going to do if you get injured? All right, but that's an aside. Back to the main topic. If you're a nonprofit with employees, you probably need this coverage too. So who's an employee? Very good question. Well, anyone who's providing services to a for-profit business could be found to be an employee of that business for workers' comp purposes. Okay, so please remember that. We're talking about for workers' comp purposes. A nonprofit, 501c3, well, anyone who's compensated could also be found to be an employee of that business. The most obvious exception on the not-for-profit side is teachers and clergy. The nonprofit can choose not to cover them, but the nonprofit can also choose to cover them. Oh, by the way, this does also include internet businesses. There's an awful lot of talk about the term independent contractor, and that is a term that's widely used and it's used imprecisely. So, for our purposes, we're back to the idea of the workers' comp world. You could very possibly be an independent contractor for tax purposes because the tax department and the IRS, they use their own laws. You might be an employee for workers' comp purposes because we use our law. And the fact you're getting a 1099, that is not determinative in and of itself. That means you're getting a 1099, but that doesn't automatically make you an independent contractor in our world. The standard we use in our world is known as direction and control. All right, what do you do if there's an injury? We're going to speak about the employer and the employee now. Number one, someone got hurt, someone got sick. Well, our mothers were right. Get your health taken care of right away. Go get the medical treatment that you need. Employers, if you want to help a worker get to an urgent care, thank you. But you don't have the authority to direct a worker to a particular urgent care, upon the first treatment. Also, sometimes I hear about workers telling me that employers are in the exam room with the doctor. Well, if the worker doesn't want the employer in the exam room with the doctor, I think that's covered under health department law already. You can choose who's in there with you, workers. This tends to happen particularly with farm workers when there's a language situation. All right, so step one is get the necessary medical treatment. Step number two, workers, you should tell your employer in writing that there was an incident. You should do it quickly. Don't wait more than 30 days. And when we say writing, I'm going to recommend that you use an email or a document for the simple reason that there's an audit trail available there. You can use a text message, and everyone uses text messages for everything. However, suppose I ask you to produce a text that you sent 11 months ago. You might not be able to do that. Your phone might not even save texts more than 30 days. That's a setting, by the way. So that's why we recommend, even though a text is lawful, it's okay legally, we recommend you do something that you can find. Now, once that notice is given to the employer, here's what employers must do. Employers, you got the notice that there was an incident, you need to tell your insurance payer right away, please. Adam, all the insurance payers on the line are jumping up and down with joy right now because this is their favorite thing. And I agree. Tell them right away because they have 18 days from the incident or 10 days from when you gave them notice, whichever's later. They have that period of time to file a notice with the board saying there was an incident and also to begin paying benefits. It's the same standard. So tell them right away. Workers, while that employer insurance contact is mandatory, for workers, you may also file a C3. It is not mandatory for you, but you certainly may. We recommend it. And Adam has been kind enough to open up the page on our website where you can just fill in these boxes and you've filed yourself a C3. You can do it on paper too if you wish, but please use this if it's at all possible because then we don't have the handwriting and it's faster and much, much cleaner. Okay, if an employer has a relationship with an urgent care facility, how firmly can they request that you go there? About that firmly, hey, this urgent care is close by, but that's about it. You can't direct them there. And if you have a relationship with an urgent care facility, what's the nature of your relationship? So you see how you start to open up additional questions? Adam, are these slides available for people to print?
These slides are not, but if you go to our YouTube page, New York State Workers' Compensation Board, you just type it in the search bar on YouTube, you will find a recorded version of this presentation. So we recommend you go there for that.
Thank you, Adam.
You're welcome.
Okay, so we just knocked out a couple of questions. So once you've filed your C3, you're going to pursue additional treatment as needed. You might not need any more. It might be just a poison ivy. But, you know, if you do need the additional treatment, go and get it, because now your employer told the carrier, the insurance payer, who's told us. Now, when you go to the doctor, you tell the doctor this is a work-related incident. We get that, and you're going to have yourself a complete claim. Last thing we want to mention here, you have 2 years after incident to file a claim. 2 years after incident. And that's everything except World Trade Center. World Trade Center has different rules because of the nature of the illnesses that are developing. Now, Adam's got something for you.
Yes, thank you, Joe. You're going to see a scenario here on your screen. Joe and I want to get your thoughts and opinions on this. So we have Kadir. Kadir is not an American citizen. He is in the United States on a work visa. He does work 40 hours a week on site at a software company at an assigned desk using the company's equipment on tasks that the company assigns him. Kadir works 8 hours per day. His start and end times do vary, and he is being paid on a 1099, so the software firm considers him to be an independent contractor. One day, Kadir is inattentive, and he drops a computer server, and it fractures his left leg. The employer calls an ambulance that takes Kadir to the hospital. Now, under this circumstance, Joe and I would like to know if you think Kadir should file a workers' compensation claim. I'm going to open up a poll. You should see it on your screen now, and we want to get your opinion, just yes or no. Just choose your answer. All right, and Joe, we're getting the answers in now.
Let's give him a moment.
We will give you a moment.
Everybody's choosing the right answer. Well, they were until I said something.
So right now it looks like the majority of folks in the webinar today, Joe, think that Kadir should file a workers' compensation claim.
Yes, it's about 10-1, folks. And Adam and I also think Kadir should file a workers' comp claim in this instance. I'd be interested to anyone who thinks Kadir should not, feel free to put your thoughts why into that chat box. However, we think that Kadir should, and we did put a few little misdirections in there, a few what are known as red herrings. He's not an American citizen, so what? He's here on a visa, so what? He works 40 hours a week. He works on site, and the software company's directing his activities and giving him the equipment to do his assignments. So it could be considered direction and control. He's on a 1099, so what? And he's inattentive, it's okay. The employer called an ambulance. That means the employer had notice, by the way. So remember, we're just saying, should he file a claim? We're not saying he's going to get the benefit. Should he file? Yeah, we think he should, because there's no penalty to filing a comp claim so long as you're truthful. Someone, Adam, did offer an idea. Shouldn't independent contractors have their own insurance? Well, if you're an independent contractor, it might be a good idea if you have your own insurance, yes, but in this instance, we don't think Kadir is an independent contractor. We tried to give you enough facts to make you think that he might be considered an employee for workers' comp purposes. Please remember that. We can come back to this later if you'd like. All right, let's talk about the benefits of workers' comp now. There are 3 primary benefits: the medical care, the lost wages, and then finally there's a fatality benefit. So we'll do it in this order. Medical care, or I should say health care, because psychological care, podiatric care, chiropractic care, those are beyond medical care. Health care is available to workers for their workers' comp injuries or illnesses at no cost to them. This is also a lifetime benefit. This is very important, and this will be the answer to some of your questions in 20 minutes, I promise you. Remember that workers' comp provides lifetime medical care. That means you could have an accident tomorrow and get treatment for it over the next 6 months and feel terrific for 10 years. And then 10 years from now, all of a sudden you're having an exacerbation, a flare-up. Just go back to the doctor because it's a lifetime benefit. Also, someone has asked us already about travel reimbursement. Well, the transportation costs to and from your healthcare appointments are available for reimbursement. You would use Form C-257. That is available on our website, and it's in the most frequently requested forms, so it's pretty easy to get. You fill in, where you started, where you went to, where you ended up, you put the miles. If you used a car service or a bus or subway, if you can get a receipt from the bus and subway, that's good. Otherwise, you might want to just indicate that. If you used car service or an Uber, Lyft, that kind of thing, you should probably attach the receipt. And you can go back to day one. So if you have 10 years of these trips, you can go back 10 years. I would just suggest you put them on multiple forms because the insurance companies do have to go through each line, and they do have to verify that this actually happened. And the way they verify, by the way, is they look in the claim folder to see if there's a medical bill for that day. So if there's no medical bill for that day, they can't verify you made that trip, actually. Here's some more on the topic of medical care best practices. I'm going to skip to the last bullets first because they're the easiest. You're a worker, you're going to your appointments. Why don't you bring your WCB case number? That's the number we assign to your claim. It's 8 characters. It very probably begins with the letter G. It's not assured, but very probably it does. Also, the insurance payer is going to assign its own case number. Bring that. And bring the name of the insurance payer because the doctor has to submit the bills and the reports to us and that insurance company. So do your healthcare providers a favor. Give them a shot at getting paid here and at moving your claim forward, please, with this info. Also, very important point. If you have a temporary disability, and remember, all injuries are temporary at first. If you're permanent, you'll know it. That'll happen some years down the road. But at the beginning, when you're temporary, if you're getting a payment for lost wages, you need to go see that doctor every 90 days minimum because that doctor is going to give some opinions, including an opinion on how disabled you are. That is known as a degree of disability. That's hugely important because degree of disability is one of the terms in the equation that yields your lost wage benefit. And we will discuss that in a moment. So feel free to remind your doctor to give an opinion on how disabled you are and to include that in the documents. If you're at a medical office right now, you can use our template report, which has the 3 questions on it that you need to answer. And that's pretty much what it has on it, so it's pretty simple. But if you don't want to use our template report, if you're going to use your own report or your treatment notes, would you please add to your treatment notes the questions, work status, causality, degree of disability. It is also possible for the insurance company or payer to send you to an independent medical exam. This is known as an IME. Here's some important information for workers regarding attending an IME. Number 1, yes, they can ask you to go to this. Number 2, you may bring a witness. Even in the time of COVID, no one can tell you no witnesses allowed. So if you want to bring a witness into that exam room, you may. You may also record the exam. video and audio. You might want to use that cell phone. Your witness might want to do it. The reason you want to do that is because there will be a report generated. You will get a copy of it. Your lawyer, if you have one, will get one. The insurance company's getting a report. Everyone's getting a report. You might want to read the report. Actually, you do want to read the report. You should check it, and you should make sure you not only understand what it says, but you should make sure that all the conclusions in there and all the statements that are made in there are true. And if there are any findings in that report, well, you have the video audio record to compare the findings to. It is true that sometimes, in medical testing, we lay people, we're not going to understand what happened. But if it's not obvious to you when you look at the video record, someone who's more knowledgeable could look at that video record and possibly say, oh, yes, that is here. Here's where it is. Or it could say, no, that's not here. Where is this coming from? And if that is the case, you can make a complaint to my office. I will definitely read it myself. I will definitely review it. And as appropriate, I will send to the practice committee, because we do have a committee that does review these complaints, and the IME companies are licensed or authorized, I should say. They're authorized by the board to operate in our system. And if they're behaving quite badly, we can take that authorization away, and we have. If you have a complaint about the findings, their doctor says you're 0% disabled, go to work. Your doctor says you're 100% disabled, you can't work. Well, that's not conduct. That's a difference of opinion. That's going to have to go in front of a judge. But if you have a complaint about conduct, such as I described, or if you weren't seen in a medical facility, that sort of thing, they kept you waiting 4 hours, they kept you waiting on an exam table, well, that you can tell us about, and that we absolutely do review. And don't forget, you can claim that travel reimbursement to and from these exams. Whew, that was a lot, Adam. All right, now the cash benefit. We call it indemnity. That is the jargon term for this, indemnity, if you ever hear that. Here's how it works. The indemnity benefit is equal to, or is going to be, 2/3 of the worker's average weekly wages. Average weekly wage is a term we use. Sometimes they call it AWW because they love acronyms. And the average weekly wage is simply how much per week, on average, the worker earned in the previous year before the incident. So we do that math, we get that number, and then the maximum benefit is 2/3 of that number. It's 2/3, I think when they established this 100 years ago, they were thinking, this is a tax-free benefit, and it is. There are no taxes taken from workers' comp payments, nor are any due. And this is a common question every April. No, there's no W-2 related to workers' comp payments. But all compensation counts. So if you have 2 jobs, you need to tell us about both jobs. If you got bonuses or overtime, you need to include that because all compensation counts. If you get housing as part of your job at no cost or discounted, if you get housing, you need to tell us about it because it has value and it counts. Right now, the maximum amount a worker can get per week is $1125.46. That number adjusts every July 1st. On July 1st of this year, it's going to rise almost $20 a week. And it adjusts every July 1st because it's based on New York's statewide average for the year before. So I'll save you the math. When it goes up July 1, that's based on an average annual pay in the great state of New York for last year of about $89,000. So that's the average pay of the average worker in New York last year. If you didn't earn that, try not to feel too badly, because the salaries of the New York Yankees and Wall Street and Hollywood actors who live in lower Manhattan, well, all of their numbers go into that too, so they push the number up. All benefits, or all injuries, I should say, are considered temporary at first. So you can get this benefit weekly for periods of time when you can't work. If you are so injured that it turns out your injury is permanent, that's going to happen a year or two or further down the road. And then there are permanent benefits available. There's permanent partial disability. So you're 25%, 50% disabled. You can get that for up to 10 years. If you're permanent total, you are permanently totally disabled, you can get that payment for life. There are also payments available if you lose the use of a limb. So we're talking about arms and hands and fingers and legs and feet and toes. If you injured, say, your knee, and you had a knee replacement and it just didn't heal 100%, the doctor says, I'm sorry, Mr. Adams, but you're only 90% well. There is a benefit available for that 10% loss of use that you've incurred. We could do an entire session just on this, but finally on this topic for right now, I just want to give you a best practice, please. Please note where you were working when you got injured, and by that I mean the address of the place. There is a huge difference between us getting a C3 that says I got hurt in Midtown versus I got hurt at 7777 East 40th Street. Big difference. Because if you're, say, in construction and you gave us the address, we can pull the building permit, and then we know all the contractors, subcontractors, insurance companies in the mix. It will save you months of hearings if that ever becomes an issue. And if you're someone who represents injured workers, like an attorney, let's say, would you please get that address before you file? Here's another best practice. Well, before I do it, what if you're a new employee? How does your AWW get estimated? We can use what's known as the payroll of a comparable worker. If we're not going to use like your previous 52 weeks, these are things judges decide, but if we're not going to use your previous 52, we can use what's called the payroll of a comparable worker. So if you have a colleague sitting next to you at the same job who's been there 10 years, we might use that person. Back to the best practices, Adam. If you're going to be getting a benefit paid to you, the weekly benefit, which, by the way, is paid every 2 weeks, it's called the weekly benefit, but it comes every 2 weeks. If this is you and you can get a bank account, would you please sign up for direct deposit? I'm not going to belabor this point. I'm just going to say I can see no reason why you would not sign up for direct deposit of ongoing payments in the year 2023. Finally, if you get paid in cash, that's okay. Cash is legal tender. But what we recommend is you keep some records, as in buy a notebook, open an electronic file. Every time you get paid, why don't you note who paid you, on what date, how much money, for doing what services? Because then, if you have a comp claim, you're going to need to say what you earned in the previous 52 weeks. Now you have a contemporaneous record, and that, I'm pretty sure, will be a very good thing for you. Finally, this is the most sobering moment. This is the fatality benefit. There is a benefit for workers who perish due to employment, and by that we mean you either died right there on the job, or you died afterwards, or you died from something that is employment related. Adam is showing right now the filing a fatality claim sheet that we have available on our website. And I'm essentially now going to explain what it says, which is, number one, there are funeral and memorial expenses payable to the surviving family. In New York City, Long Island, Rockland, and Westchester, it's payable up to $12,500. In the rest of New York's counties, you can be reimbursed up to $10,500. Who can claim this benefit? Well, it's in this order. We look first for a spouse, a lawfully wed spouse, and the gender of the spouse is not a factor. If there's no spouse, or if there is an addition to a spouse, the children, spouse and children can share this benefit. There's a little bit of a formula about how it's divided. Children are eligible up to age 18 or up to age 23 if they are attending an accredited higher education institute. There are also disabled or blind dependents of the deceased. They can also share this benefit. This benefit is calculated just like the lost wage benefit, but you're going to get the most that you are eligible to receive up to that maximum. If none of these parties exist, $50,000 is payable to the parents of the deceased worker. If those folks don't exist either, $50,000 is payable to the estate. So we will be dealing with an executor and executrix. If there are other family members, you will have to deal with the estate. These are the only parties that the comp claim can pay. Finally, there is an organization known as Kids Chance. Kids Chance is a national nonprofit that has a chapter in every state. They provide scholarships to the children of New York's fatally or seriously injured workers. Adam is showing you the website right now. You can see the address is kcnewyork.org. They provide scholarships, and I can tell you that they do have scholarship money available even now on May 17. And it's a really good time of year to be thinking about scholarships because you're probably filling in financial aid forms and getting ready for college in August. So I would encourage you to visit that site. We are not affiliated with them in any way, but we do feel comfortable pointing out that they do exist for you and they could maybe be very, very helpful to you. New topic, COVID-19. COVID-19 is an infectious disease. Infectious diseases are payable in the workers' comp system. There are a few elements that are particular to COVID-19 claims that we'd like to call out to you. Number one, the medical reports are going to be key. Remember I talked about telling the doctor you had a work-related incident and giving them your claim number and the insurer's claim number? Well, if you see the doctor in the case of a COVID, you're going to want to explain to the doctor the details of your workplace because the doctor is going to file an opinion on what's known as causality, as in, does the doctor think it's reasonable to assume that you contracted COVID due to your employment? Because you don't have to point to a moment in time when you were infected, but the standard we use is called prevalence. Or was COVID prevalent in your workplace? Is it likely you got COVID in the workplace or due to employment? That's the standard we use, folks. Likely, how likely is it that you have COVID due to employment? So that's why you're going to want to discuss with the provider the details about did people wear masks? Was there COVID in your workplace? Did your coworkers have it? because that counts for workers' comp purposes. Also, there's the PCR test. If you have a PCR test, you need to file that, please. That's going to show pretty convincingly that you actually had COVID. We don't use the private home tests in this system because it's an insurance-based system. We use the PCR test, but if you have it, file it. There is a lot more to say about this. We do a webinar periodically, don't we, Adam, on COVID? If you want to sign up for that or get the dates, visit the webinar page on our website. You can also visit the COVID page on our website, and you can see all of the links we have. And look at that, right across. Yeah. So we have quite the comprehensive web page here on COVID, wcb.gov/COVID-19. So please give that a visit. And if you believe that you got COVID due to employment, I'm urging you to file a claim because workers' comp has lifetime medical care. So if you get a COVID claim established, well, if you need more medical care in the future, let's say you have what's known as long COVID, well, it's there for you. Now, Adam has something else to say.
Thank you, Joe. We're going to get another poll going here. We want to get your thoughts here on Liz. Liz worked at a big box store in the seasonal department during the holidays where she dealt with the public. One day, Liz felt ill and she called in sick to work. She took a PCR test. It came back that she was COVID positive. She received her paid sick leave for 2 weeks of work that she missed. And while she was at work, she was very vigilant about following all COVID protocols. She wore a mask, she social distanced. And at that time, several of Liz's coworkers also had COVID-19 during the same time period. So a poll is going to pop up on your screen again, and we want to get your opinion. Do you think Liz should file a claim for COVID-19 exposure at the workplace? And again, we're going to give people a minute or two to put their answer in. We do have answers coming in, Joe. We can get our, usually some Jeopardy music. All right, looks like, again, we have the majority of folks saying that, yes, Liz should file for a COVID-19 claim. We got a few no's, but for the majority, mostly yeses.
All right, we believe that Liz should file a claim, a workers' comp claim for COVID. I'm happy to note, Adam, that less than 6% of respondents say no. If you would like to indicate in the chat box why you think no, then feel free. But we tried to give you enough reasons to think it's certainly starting to look possible that she got it at work. And remember, there's no penalty for filing a workers' comp claim so long as you're truthful, even if it's not established, even if it's what's known as disallowed. There's no penalty. Some people, Adam, I'll bet, saw the paid sick leave and said, why would she file a claim? Well, remember, the paid sick leave, that's going to be funds, that's going to be money, but the workers' comp claim provides lifetime medical care should you need it. I see that a question has come in about COVID, but we will address that in a little while because it's a relatively serious question. I don't want to go quickly through it. There are penalties for late payment. We mentioned earlier, employers, you better tell your insurance payers right away there was an incident, please, because yes, they have 18 days from the incident to begin paying that lost wage benefit, or 10 days from when they got notice, whichever's later. So if you tell them on day 2, 10 days from that is day 12, but they have 18 days, so it'll be the 18 days that are used. Also, if you have a hearing, there's going to be a decision. There'll be a date on that decision in the lower right-hand corner. The benefits have to be paid within 10 days of that decision, or a penalty is due to the worker. Worker, you're going to have to keep track of that and then ask for it. Also, interest could be payable in some circumstances after appeal. Finally, In the case of ongoing payments, remember I was talking about direct deposit? Well, I have to tell you that under the law, your paper check is not late until it's 25 days late. That's why I'm asking everybody to please take direct deposit. It's so much more reliable. Workers, you do have a few responsibilities. For one thing, you should try to return to work when you're ready, when you're physically capable. Enlightened employers will have something known as light duty or transitional duty available for workers who are maybe mildly disabled, but who could do some form of work in the workplace. You know, let's say you're a laborer, okay, and you work with your hands, you work outdoors for a company, but you're also going to college at night to learn accounting, and you're injured, but now you're almost healthy, but you're still not 100%. Your doctor gave you some physical restrictions. Well, maybe the company needs some help with its books, which you can do. You can go back to work and work in the office for 4 weeks and help them on that, in that task. That is very good for the worker. It's very good for the employer too, because the worker comes off a workers' comp and is making a contribution. We have an enormous amount of resources on our website regarding return to work, so I would encourage you to visit our website and search for return to work. Also, this last bullet is huge. If you're a worker, please consider signing up for eCase. eCase is the tool that you can use to see all the documents in your claim. You will find that very illuminating and very helpful. It's pretty easy. You would just click that Register for eCase button, fill it in. We have staff available who can also help you with that if you have any questions. We do sometimes have hearings. Well, slightly more than 250,000 times a year, actually, we have hearings. And you and your representative, if you have one, will be attending the hearing. You can hire an attorney if you wish. It's not mandatory, but attorneys can be very helpful, especially in certain types of claims like disputed claims. I would really urge you to talk to an attorney if your claim is formally disputed. The insurance company is definitely going to have an attorney at that hearing, and it's going to take place in front of one of our law judges. We are not as formal as courts. We don't operate courts technically. We don't use the formal rules of evidence procedure that are used in civil court and criminal court, but we do operate predictably, regularly, and with the typical decorum that attorneys exercise in hearings. Could have witnesses, could have depositions presented. If you're a worker, I'm going to urge you to make sure you are there for your hearings. But now the question is, how are you going to be there? Well, we are still closed to the public, so all of our hearings are virtual. Now, this is a very good thing because we had this in place when the pandemic struck and we didn't lose hearings because of the pandemic, unlike the unified court system, for example, who couldn't do hearings. Our hearings went on uninterrupted. So essentially, we do a teleconference. If you have a phone with a camera or a tablet with a camera or a computer with a camera, you can join this in that manner. Everyone is on the teleconference. Please don't come to our offices looking for a hearing because we're not holding in-person hearings for anyone. But if you'd like to download the app, visit Apple's store or the Google Play Store. Is that the other one? So you can visit either of those major providers and you can download the app. You will also get a hearing notice, and the hearing notice will also contain information for connecting if you'd rather go through the web direct in that manner. The hearing notice will also give you a phone number. If you want to attend by phone and not use this method, okay, you can. but you need to tell us by the morning of the hearing that you need to do this because the judge calls you. The judge calls you. So you need to tell us what number to call and that you want a phone call. Here are our social media channels. 1, 2, 3, we have 4 of them, and then we also have the notifications, the last one. I would encourage you to sign up for notifications in whatever variety you like. You can follow us in all these manners. Here's the contact info for my office. I think we'll leave this up, Adam, while we do the questions. What do you think?
Yep, sounds good. As I mentioned, please enter any questions you have in the chat box. If you look on the lower right-hand side of your screen, there's a little chat bubble. You can push that and the chat will pop up. We do have some questions that have already come in. So Joe and I are to review those questions that have come in, and we'll be back with you shortly. Thank you. All right, so our first question here, in terms of getting information about NICE COBRA.
Yes, someone is asking about COBRA for New York State employees, I do believe. And I'm terribly sorry, but this is not a workers' comp topic. I would suggest if you are a state employee, maybe call the Business Service Center or check with your agency.
All right, thanks, Joe. Going back to the independent contractor, on top of whether or not the independent contractor should have their own insurance, what about if the fact that if an employer considers the employee to be an independent contractor?
Okay. All right, so 2 sides here. You are a true independent contractor, you're not. Okay, so if you are truly an independent contractor, you have your own private business, your own business cards, your own contact info, your own tools, etc. You come in and out of a site, great. The economy needs you. If you would like to purchase comp insurance for yourself, go on ahead. We would recommend you talk to a few different insurance companies, get multiple quotes. The coverage is all going to be the same, but get multiple quotes and see which one is best for you. You know, I said the coverage is all going to be the same. The benefits are the same, but there are deductibles that are possible in comp insurance. Okay, so, but the other side of that, Adam, is what if my employer considers me an independent contractor and there's an incident? Well, what we would say is if you're not the instance I just described where you're clearly an independent and you know you are and you fit everything I just said, you can go ahead and file that claim because the employer's opinion is not the only thing here. Now remember, there's the employer and then there's the insurance payer. It's actually the insurance payer's opinion that's going to matter the most because they make the filings. They hire the attorneys to come and represent them because they have to pay the claim. So you can go on ahead and file that claim.
I did see another question come in asking about a copy of the slide deck. I mentioned before, we don't have a copy of this slide deck available to download, but if you do go to our YouTube page, I'm going to real quick just pull that link up again. Right there, youtube.com/NYSWCB. There is a recorded version of this webinar on there, so you can go ahead and check that out. All right, next question. Am I correct in understanding that timely filing claim is 2 years from the date of injury?
You are correct. That's the time limit. Yes. There is a little exception. Let's say you're beyond 2 years. There's this tiny exception about having received what's known as an advance payment of compensation. That might bring your claim in, but generally speaking, let's stick with the 2 years.
If an employer has been paying an employee under the table, can that employee still file a claim?
The answer is yes. The employee is probably being paid in cash, and I would recommend the employee keeps a record of those cash payments, but the answer is yes, and we do not have mutual reporting with the Departments of Taxation, by the way.
Can you please talk about return to work policy from an employer standpoint?
Yes, I can. I'm very happy you posed this question. I gave you a little bit during the presentation, But from an employer standpoint, return to work is an excellent idea. It's an excellent idea for two reasons. Number one is just on a human level, why wouldn't you want to bring the worker back? Because it benefits the worker and you have that connection, and you also have the fact that all the studies show the sooner a worker comes back, the better the outcome. The better for the outcome for the worker's health, but also, here's part two of what I was going to say, it's better for the employer, not only because you're getting a contribution from that person, but because it's going to help your workers' comp rates. Because the worker might need less medical care going down the road, but the worker will definitely not be receiving the indemnity benefit because the worker's back on the payroll. So remember, all the expenses in a workers' comp claim get figured into your claim experience, which gets figured into your premium. So if you're reducing the amount of money spent in indemnity because the worker came back, you're reducing the pressure on your premium for the future.
All right, we did have a question on COVID-19 that we wanted to go back to. Someone's husband passed away from COVID-19, and through an appeal, the board did determine that it was prevalent in the workplace. However, the family is still having to go through the hearing process, and so, Joe, would you like to take a minute to discuss why that is?
Yes. All right. I'm glad that the appeal found that the claim was payable. The technical term for that is compensable. So that's good news. Why are there still hearings? Well, it would depend on what the decision actually said specifically, because it is possible that the decision said, yes, this is a compensable claim. It is now established. But maybe the judge didn't get into a position where the judge made awards, where the judge said, here's how much needs to be paid to the family per week. Or maybe it's an instance where at the hearings the claim was disallowed, and then it was appealed and the board found it compensable and payable, so it's allowing the claim. So now we need to go through the rest of the process to determine what amount of money should the family or the estate receive. Well, the estate would just get $50,000. But what amount should the family receive, and do we have all the documentation that's necessary to establish the relationships, as in the marital status or the children and their ages and so on. So yes, if this is happening, it's just because it's a very complex claim, but hang in there, you're probably almost finished.
All right, thank you. Next question, is it legal to fire an employee for trying to make a claim? What about if the employee is not a legal immigrant?
All right, two questions there. Number one, the immigration question, just don't even worry about it. Immigration status, not a factor, period. Now, on the other side, is it legal to fire an employee for trying to make a claim? No, it is actually not legal to fire an employee for making a workers' comp claim. That is specifically precluded or excluded under Section 120 of the Comp Law. So if that should happen, number one, if you're an employer, please don't do this. Number two, if you're an employer who did this, call the worker and bring the worker back, because number three, the worker can file the DC 120, D for discrimination, C for claim, 120, and there's going to be a hearing at the board in front of one of our law judges, and if the law judge agrees the worker was terminated for filing a claim, the law judge has the authority to put the worker back into employment and award back pay.
All right, next question. What is the time from when an injury occurs to the time to be seen by the provider?
How about as soon as possible? I mean, it's really that simple. I mean, if you're bleeding or you're dizzy or something, go get your medical care. There is not such a standard as you might be wondering about.
If you are not out of work for more than 7 days, is the employer responsible to pay the employee?
All right, this is a more complex question than it looks like, but I'm glad it was raised. The background here. I mentioned the lost wage payment. Well, here's a little more detail on the lost wage payment. If the worker misses less than 7 calendar days, there's no lost wage payment. If the worker misses between 8 and 14 calendar days, excuse me, well, the worker could be paid for days 8 through 14. If the worker misses 15 days or more, the worker can get paid back to day 1. So, back to the specifics of our question. The worker has missed less than 7 days. It is now a workplace question between the worker and the employer regarding what sort of time off benefits the worker might have to get paid for those days. I can just, generally speaking, as one human being to another, just encourage an employer, if somebody got hurt in your employment and they missed 2 days of work, I would really encourage you to try and do something to help that worker out.
Are there specific requirements regarding filing and management of bloodborne pathogen claims, and are injured workers required to obtain baseline testing and follow-up testing?
Wow, that's a question. And the answer is actually maybe. Now, what I mean by that is, are there specific requirements regarding filing bloodborne pathogen claims? No, there are not. But the rest of the question, it starts to get into how are we going to handle the claim, how are we going to prove? Well, now you're getting into potential moments of litigation. So what I would suggest is, if this is you, definitely file that claim. Definitely think about possibly hiring an attorney, especially if you get that claim disputed. But you might not have it disputed either, so you might not even have a hearing. Definitely file that claim, though, please, and get the medical care you need. And Adam, actually, at this moment, I would like to call out the occupational health clinics, because when we're talking about something like a bloodborne pathogen claim, well, you're going to need a lot of expertise, probably. And you might want to consider one of the occupational health clinics that the New York State government is helping to operate, or fund at least, across New York State. So if you need one, just go onto a search engine and put in New York State occupational health clinics. There are 7 of them. Adam and I know those people. We work with them regularly. And then you can go to the one nearest to you.
If you get sick at work and they take you to the hospital and after the ER visit you continue being sick, can you claim compensation, and how long will the compensation last?
Well, certainly, and we've just spent an hour discussing all the rules in that system. So what I mean to say is, yes, of course, if you get sick due to employment, DUE, if you get sick because of employment, that's a workers' comp claim. If you get sick with something that is not related to your job, but it just happened to happen while you were on the job, then no, that's not going to be a workers' comp claim. Remember, the key here is your employment was related to your illness, or your illness was related to your employment. And technically it's called in the course of employment and out of the course of employment.
Can you just confirm that injured workers have to be out of work for at least 7 consecutive days to receive the benefit?
Workers at the start of their claim would not be due indemnity until they had missed 7 calendar days of employment. It's not 7 work days, by the way, it's calendar days. So that means, let's say you got hurt, let's say you got injured on Monday. So you missed Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, Monday, Tuesday. That's the 8th day, the next Tuesday. But what I'm saying is, number one, don't think I'm telling you not to file a claim, because absolutely I'm telling you to file a claim if it's work related. Number two, if you're an insurance payer, I don't think you're asking me this question because you know the rules. So if you're a worker and you got hurt on Monday and you came back to work before the next Tuesday, you might not be due any lost wages. But, let's say in 2 weeks you end up missing another week, well, you could qualify for the indemnity benefit then. Also, let's say 6 months from now there's a surgery and the worker misses 4 weeks to recover, indemnity benefit's going to get paid.
When requests for services are denied for claimants, should they reach out to an advocate?
Sure. If you're referring to my office, the Office of the Advocate for Injured Workers, if you have followed the process and your doctor has requested a variance for a treatment and it was denied, if you'd like us to help explain it, we certainly can. If you'd like us to look at it and see if maybe something went wrong, we certainly can. So, yes, if you need some help, feel free to ask.
Can you add your travel for reimbursement directly to eCase, or do you have to mail it in?
This is a really technical question, and I'm glad it was asked. So you're a worker who's filled in a C-257. You're asking for mileage reimbursement. How do you get it here? Well, you could mail it through the U.S. mail. That's fine. Or if you have it in electronic fashion, and I do mean a PDF, okay? Adam, did you know that we do not take photographs in the claim folder?
I think I did know that.
I think you did too. However, here's the point. You can't take a photo of your C-257 and send it in because we don't take photos. You can, though, you can file PDFs or any documents in that format to us directly via email if you use the address wcbclaimsfiling@wcb.ny.gov. The address is at our website, I promise you. So you can send the paper or you can attach a PDF to an email, put your claim number in the subject line, and send it there. You can also send a copy to the insurance company, however they take it. But please, if you're sending it there, you have to send it here so we know about it. And if you send it here, you don't have to technically send it to the insurance company because they're responsible for anything in your board file. But it's not only nice, but it might actually get you the payment quicker because it puts it directly in front of them.
I'm on workers' comp and don't have regular medical insurance. Can workers' comp help with regular doctor's appointments aside from the injuries?
No, I'm sorry. The workers' comp insurance will only cover your established workers' comp injuries.
We have a question here about cash payments. We'd like to know, what is the board doing from an employer standpoint? It's fraud if they are underreporting their payroll, true?
Okay, this is a pretty big global question. Well, okay, our questioner is saying if an employer is paying workers in cash, isn't it possible that the employer is misrepresenting its payroll to the insurance company? And I suppose it's technically possible that they might be underreporting their payroll to the insurance company. So we do actually, at the board, we do have compliance investigators, and they do review business records, and they do review those types of matters. And so, yes, if the Compliance Bureau gets a complaint like this, They absolutely take it seriously and absolutely will look at it. If you'd like to make such a complaint, please come to the website and look up the Bureau of Compliance and give them a call or send them an email. They would like to know about this. There's also the New York State Fraud Inspector General. And the Fraud Inspector General absolutely does these sorts of investigations as well. Okay, somebody's asking about the 2 years. This is a rather technical point, but employees should notify their job, I'll say, or their employer within 30 days if they can. The 2 years is to file the claim. Okay, so just remember, let's stick with that one. 2 years to file a claim.
All right, that is all the questions we have, so we are going to go ahead and wrap up. I want to thank you all for joining us today and participating. We always appreciate you taking the time to join our sessions and ask questions. We are happy to answer them. Thank you to Joe for taking the time to give the presentation and answer your questions. Just want to remind you before we sign off that as part of the Advocate for Injured Workers series, this webinar will continue to be offered in the coming months. So if you need a refresher at any point, or if any of your colleagues couldn't join today, there will be other opportunities. You can find a list of the upcoming webinar dates for this series, as well as a variety of other topics on the board's website. If you go to wcb.ny.gov/webinars. Again, we mentioned this earlier, you can also sign up to receive workers' compensation news, including information on future webinars straight to your inbox. To sign up, just visit the Workers' Compensation Board website, scroll down to the bottom of the homepage, and select Get a WCB notification. We also distribute information on social media, so please be sure to follow the Workers' Compensation Board on Facebook, Twitter, Instagram, and YouTube. Again, that YouTube page does have a recorded version of this presentation, as well as dozens of other webinar presentations we've done in the past, so we highly recommend you check that out as well. Thank you again for joining us, and please enjoy the rest of your afternoon.